Hello, my name is Peter Walsh. I'm an attorney licensed to practice law in the states of Wisconsin, Illinois, and Florida. My legal practice focuses on the areas of estate planning and asset protection planning. Today I will be discussing asset protection planning for long-term care. This presentation is a summary of the planning techniques set forth in my book, The Basics of Wisconsin Long-Term Care Planning. That book and additional materials are available online at www.wismedicaid.com. Today's presentation is organized in terms of commonly asked questions. It is intended to provide only general information and is not intended to constitute legal advice to a specific situation. You should consult with an attorney regarding your particular circumstances. Please feel free to contact me with any questions you may have on the subject. Throughout this presentation, I will be using the term applicant to refer to an individual in need of long-term care or a person applying for long-term care insurance or Medicaid benefits. What is long-term care? Long-term care describes the care required for an applicant who, due to a disability or old age, needs assistance performing activities of daily living. Activities of daily living include eating, bathing, dressing, moving about, and toileting. Long-term care services are generally necessary when an applicant cannot independently perform two or more activities of daily living. This care can be provided by caregivers in the applicant's home or through services offered in an assisted living or nursing home. What is long-term care asset protection planning? Long-term care asset protection planning generally involves the purchase of an insurance product or the transfer of assets to shelter wealth in the event of a long-term care need. Insurance may provide an alternative source for paying for long-term care or a means of recouping funds spent on such care. An applicant can also transfer assets to shelter them from a Medicaid spend-down. Why is it important to plan for long-term care? Proper planning can preserve substantial wealth in the event of a long-term care need. Long-term care is extremely expensive. For example, the median cost of an assisted living or a nursing home in Milwaukee exceeds $4,000 and $8,000 per month respectively. Care at home is similarly expensive. Unfortunately, there is a strong likelihood that we will all eventually need some long-term care. Consequently, we all face the risk of incurring these very high costs. Planning can reduce these costs. How can you plan to cover the cost of long-term care? Planning generally involves obtaining insurance, either private or public, to help cover the cost of long-term care. Private insurance comes in the form of life or long-term care insurance, while public insurance comes through Medicaid. The general intent for purchasing private insurance is to provide a dedicated funding source for long-term care. To qualify for private insurance, an applicant must be in reasonably good health and be able to pay premiums. For those who cannot obtain private insurance, Medicaid may be available. Unlike private insurance, to qualify for Medicaid, an applicant must have an immediate need for long-term care and have income and assets that are below certain minimum levels. Why can't I just rely on Medicare? Unfortunately, in many cases, Medicare is not sufficient. Medicare coverage is very limited. It only pays a portion of the nursing home costs. It may pay the entire cost for 20 days and a portion of the costs for the next 80 days, but thereafter the resident may have to privately pay for all long-term care. Conversely, private insurance and Medicaid are not so limited. How can private insurance be used in long-term care asset protection planning? Private insurance can be used to recoup funds expended on long-term care. Such recoupment may come through traditional life insurance, which restores funds expended on the applicant's long-term care. Recoupment may also come through long-term care insurance, which provides funds for long-term care expenses during the applicant's life. The benefits of long-term care insurance may include payment for care at home, in an assisted living, as well as a nursing home, payment to relatives for providing care, and a death benefit. Benefits paid on certain qualified long-term care policies can also increase the applicant's Medicaid asset limit by the amount of the total long-term care insurance benefit. For instance, if a single individual has a qualified long-term care policy with a total of $100,000 worth of benefits, this person's Medicaid asset limit is increased from $2,000 to $102,000. The disadvantages of private insurance stem from insurability and affordability. Private insurance can only be purchased by those who have no immediate need for it and who have the ability to pay sometimes high premiums. What is Medicaid? Medicaid is a government insurance program which covers the cost of long-term care. Expenses covered by Medicaid include nursing home and assisted living expenses, as well as limited at-home care. For the elderly, Medicaid is commonly used to cover the cost of extended nursing home stays. In some respects, Medicaid is the opposite of commercial health insurance. To qualify for commercial health insurance, you must be healthy and able to pay expensive premiums. Conversely, to qualify for Medicaid, you must need medical assistance and have no means of paying for it. In that respect, Medicaid is a welfare program. Nevertheless, Medicaid does not provide inferior care. Most nursing homes accept Medicaid, and federal law prohibits nursing homes from providing less care to a resident because he receives Medicaid benefits. How is Medicaid eligibility determined? To qualify for Medicaid benefits, an applicant must be both functionally and financially eligible. To be functionally eligible, an elderly applicant must have a chronic condition which causes the applicant to need assistance with two or more activities of daily living. To be financially eligible, the applicant's income and assets must be below certain minimum levels. In addition, the date on which full Medicaid eligibility begins depends upon whether the applicant made any gifts in the 60 months preceding the Medicaid application. Such gifts could cause the applicant to be ineligible for certain Medicaid benefits for a period of time. If there are no such gifts, full Medicaid eligibility begins upon the first day of the month in which the application is filed. What is the income limit for Medicaid? The income limit depends on the applicant's cost of care. If the applicant's cost of care exceeds his income, then the applicant satisfies the income limit. The applicant must use his income towards his cost of care, and Medicaid pays the excess. For example, if an applicant has $3,000 worth of monthly income and the applicant is in a nursing home which costs $6,000 a month, the applicant satisfies the income limits because his cost of care exceeds his income. For most people, the income limit is easy to satisfy. What is the asset limit for Medicaid? The hardest part of Medicaid eligibility is satisfying the very low asset limit. For a single applicant, the limit is $2,000 of countable assets. For a married couple, the asset limit is substantially higher because of spousal impoverishment protections afforded to a community spouse. To the extent the applicant's countable assets exceed this limit, the excess must be spent down or converted to non-countable assets. In this context, the spend down of assets on Medicaid expenses to qualify for Medicaid is referred to as a Medicaid spend down. Not all assets are countable for Medicaid purposes, however. Specifically, countable assets do not include unavailable assets and exempt assets. Unavailable assets are assets that cannot be converted to cash within 30 days. Examples of unavailable assets include property listed for sale, a life estate interest in real estate, and certain annuities and promissory notes. Exempt assets are assets specifically protected by statute. They include the value of the applicant's home, one car, prepaid funeral funds, and assets in a qualified special needs trust. Medicaid asset protection planning often involves the use of one or more strategies for converting countable assets to unavailable or exempt assets. Are there any protections for the spouse of a Medicaid applicant? The Medicaid rules provide protections to the spouse of the Medicaid applicant who lives at home. These protections are referred to as spousal impoverishment protections. The protected spouse is referred to as the community spouse. These protections are intended to prevent the community spouse from being impoverished by the applicant's nursing home costs. The spousal impoverishment protections generally allow the community spouse to retain substantial assets and income. For example, Medicaid exempts from the applicant's countable assets the community spouse's qualified retirement accounts and tangible personal property. It also allows the community spouse to own a home of any value. Medicaid further increases the countable asset limit of a married applicant by the amount of the community spouse resource allowance, which may be as much as $116,000 in 2013. The community spouse is further afforded certain income protections. First, the community spouse's income is not considered in determining whether the applicant spouse is income eligible. Second, if the community spouse's income is below a minimum monthly maintenance allowance of about $2,900, some of the applicant's spouse's income can be transferred to the community spouse. Can assets be given away to qualify for Medicaid? A Medicaid applicant generally cannot give away assets to become eligible for Medicaid. Such gifts constitute divestments that cause an ineligibility period. Specifically, the value of all divestments made within the look-back period are added together to determine a penalty period. A divestment is a gift of countable assets or income. The look-back period is a 60-month period prior to the date of the Medicaid application, and the penalty period is the number of days following the date of the Medicaid application during which the applicant is ineligible for Medicaid because of the divestment. The penalty period is determined by dividing the total divestments made during the look-back period by the average daily cost of a nursing home. The result is the number of days of the penalty period. For example, if the average daily cost of a nursing home is $200 a day, and an applicant reports total divestments of $10,000, the penalty period will be 50 days, which is determined by dividing 10,000 by 200. Certain gifts are specifically excluded from the divestment rules, however. For example, gifts to a spouse or to a child who is disabled are not divestments, so they do not cause a penalty period. Can Medicaid take an applicant's home? Medicaid does not take an applicant's home, nor does the state require a home to be transferred for Medicaid eligibility. Instead, the state may place a Medicaid lien on an applicant's home to recoup Medicaid funds expended on the applicant's care. A Medicaid lien essentially entitles the state to a portion of the proceeds from the sale of the home. For example, if the Medicaid applicant received $100,000 worth of Medicaid benefits, then the lien on the home would equal $100,000. If the home is sold for $200,000, then the state would receive $100,000 and the applicant or his heirs would receive the balance. A Medicaid lien cannot be placed upon an applicant's home, however, if either the applicant or the applicant's spouse reside in the home. How do I plan for Medicaid eligibility? Medicaid eligibility planning generally falls into one of two categories. The first category involves sheltering assets before long-term care is needed in order to protect the assets from a Medicaid spend-down. For example, a parent can shelter assets by transferring them to an irrevocable trust or to a child more than 5 years before a Medicaid application is filed. Gifts made more than 5 years before a Medicaid application is filed do not cause a penalty period, regardless of the value of the gift. The second category involves sheltering assets when long-term care is immediately necessary because the applicant is in a nursing home. Substantial wealth can be preserved even after the applicant is in a nursing home. For instance, countable assets can still be converted to exempt assets by making repairs to the applicant's home, prepaying funeral costs, or transferring assets to a qualified special needs trust. Countable assets can also be converted to unavailable assets by listing real property for sale or exchanging liquid assets, cash, for a qualified annuity or a promissory note. Through such techniques, Medicaid eligibility can be obtained without spending all the assets on medical expenses. For more information as to the techniques employed in Medicaid eligibility planning, please refer to my book, The Basics of Wisconsin Long-Term Care Planning, which is available at www.wismedicaid.com. Can private insurance be helpful in Medicaid eligibility planning? The purchase of some private life or long-term care insurance can be very valuable in Medicaid eligibility planning. As previously discussed, insurance can be used to recoup funds expended during a Medicaid spend down, and private long-term care insurance can be used to increase the Medicaid asset limit by the amount of the benefit paid under the policy. Long-term care insurance can also be used to pay for an applicant's care during a penalty period. For example, a long-term care policy providing for 3 years of coverage may cover the cost of a penalty period imposed on a divestment of $267,000. This sum is the equivalent of 3 years of care at Wisconsin's current average daily pay rate, which is the number used to calculate the penalty period. Unfortunately, there is a strong likelihood that we will all eventually need some long-term care. The cost of such care can be catastrophic. Fortunately, these costs can be substantially reduced by long-term care asset protection planning. For more information, please see my book, The Basics of Wisconsin Long-Term Care Planning, which is available online at www.wismedicaid.com. Thank you very much.